Now we're going to look at the other side of the coin, and that's even when an employer has a reasonably held belief that an employee's actions amount to gross misconduct, dismissal will not always be fair. Mitigating factors may mean that the dismissal was not within that range of reasonable responses that Brian was referring to, and so it wasn't an option that the employer should automatically have taken. And in Brito Babapool and Ealing NHS Trust, Ms BB was a consultant haematologist. Her employment contract allowed her to work for private patients in addition to her NHS duties. Now, she suffered with health problems which resulted in her absence between March and June in 2009. But the trust suspected that she was still working for her private patients while she was on sick leave. And they warned her on 2 occasions that if she was certified as sick, she shouldn't be working in private practice either. But she continued to do so, and so she was summarily dismissed. Well, she then brought a claim for unfair dismissal, and the Employment Tribunal decided that the trust was entitled to treat her actions as gross misconduct, and they decided that once gross misconduct is found, dismissal must always fall within the range of reasonable responses. Well, they were wrong about that. There's no automatic rule that once gross misconduct is proved, dismissal must inevitably be fair. Because as we've said, there may well be mitigating factors, such as length of service, previous disciplinary record, and also the adverse consequences that dismissal would have on that person's career. And so the EAT allowed the appeal, albeit reluctantly, and they sent the case back to the same tribunal to reconsider this particular point. Now, we included this particular case because many employers fall into the same trap of assuming that in cases of gross misconduct, summary dismissal is the only outcome. So it's important that employers are able to show in all cases that any mitigating factors have been properly considered before you reached that decision. So when you're making your decision, obviously, first of all, you've got to decide whether there was evidence which showed on balance that the individual had committed an act of gross misconduct. If there is, then you go on and consider if there are any mitigating features that you need to take into account. And then, and only then, can you decide whether summary dismissal is appropriate or not. So if you don't look at the question of mitigation, and particularly if you say words to the effect, when so-and-so was guilty of gross misconduct, so I had no choice but to dismiss them, then you do risk a finding of unfair dismissal.
Now, moving on to another topic, sometimes an employer may feel compelled to dismiss an employee because they're under pressure from a third party, often a customer, who threatens to withdraw their custom unless the person is dismissed. Now, there are situations actually in which that might be a fair reason to dismiss somebody, but it's not enough for an employer simply to show that there was the third party pressure to dismiss. The tribunal will also need to consider whether it was reasonable for the employer to dismiss the employee in all the circumstances. Now, we've got a rather odd local case here, which went to the Norwich Employment Tribunal, Scarth and Atkins Gregory. Ms. Scarth was employed as one of 8 cleaners employed by a cleaning contractor. She was discovered in possession of packets of paper hand towels and toilet rolls and was accused of stealing them. She then admitted taking them, but claimed that she'd simply put them in her car to ensure that she had a supply at the end of the shift. And the band played Believe It If You Like. Well, Atkins Gregory didn't. But for reasons best known to themselves, they decided not to dismiss her, but to give her a final warning. And now, at this point, the customer said, well, we're not having her back. So Atkins Gregory then said to Miss Scarth, well, how about this position and this position? But she said, no, I'm not taking any of those alternative jobs. She declined them all, and at this point, they did dismiss her. Well, it went, as I say, to the Norwich Employment Tribunal, and they rejected her claim of unfair dismissal, quite apart from the fact that the company had reasonably concluded that she had attempted to steal the hand towels and the loo rolls. They had actually done all they possibly could to avoid dismissing her, but she'd rejected the alternative job offers put to her. So in the end, although it was pressure from a third party which led to her dismissal, it was fair. However, that wasn't the end of the matter. You'll be hearing a bit more about Miss Scarth later, because she also brought a claim of age discrimination. So watch this space.
Okay, by way of contrast, we've also got the Bancroft and Interserve Facilities Management case. Mr. Bancroft was employed as a chef by IFM, which provided a catering service to a bail hostel under a contract with the Home Office. The hostel itself was run by Lincolnshire Probation Trust. And the catering contract gave the Home Office the right to remove or to refuse to admit any employee of the company who, in its opinion, shouldn't be allowed into the hostel. Mr. Bancroft raised a variety of health and safety issues with one of the bail hostel managers, who then began to find problems with his work. Now, following complaints about his behaviour, Mr. Bancroft was suspended and a disciplinary hearing was held at which he was given a first and final warning. Meanwhile, the bail hostel manager to whom he'd complained wrote to the Home Office requesting a permanent replacement for him, saying that he didn't want him to return to the hostel due to his inappropriate behaviour. So the Home Office subsequently wrote to the company, attaching a copy of this letter and asking for a permanent solution to be put in place. Well, the company took the view that the trust would be most unlikely to change its mind and dismissed Mr. Bancroft, having unsuccessfully tried to redeploy him. Mr. Bancroft claimed unfair dismissal, but the tribunal rejected his claim. So, you've guessed it, he appealed to the AT, which decided that the tribunal got it wrong. But the Employment Appeal Tribunal decided that the Employment Tribunal had failed to address whether the company had taken all steps to try and mitigate the injustice caused to Mr. Bancroft by the third-party pressure to dismiss. It had simply accepted the company's argument that it was pointless to even try and persuade the trust to change its mind. Now, I think it's fairly obvious to say that there are probably other factors at work here. The whole saga started with Mr. Bancroft raising health and safety concerns, and whether justified or not, it was only then that he was accused of misconduct, and the Home Office asked for him to be replaced because of his inappropriate behaviour. The Home Office paid the trust to run the hostel, and the trust paid IFM to provide the catering. So I think you can probably understand and have a great deal of sympathy with IFM that they felt that there was precious little that they could do to change people's minds. But they should have at least tried. The claim hasn't actually been finally determined because, once again, it's been sent back to the tribunal to look at this particular point. So once we know what the final outcome is, we'll mention it in our monthly newsletter.
As you're probably all aware, a claim for unfair dismissal must be presented to an employment tribunal before the end of 3 months from the employee's last day, called the effective date of termination, or EDA. And the EDA will normally be fairly clear, but it isn't always so, and this is a particularly instructive case. Ms. Hibbert, in this case, raised an unsuccessful grievance due to various issues with her employer. She was subsequently signed off sick. She had a grievance appeal. That was also turned down. And then the important points start to arise. She hand-delivered a letter of resignation, which was dated 29th of June, and her employer read it on that same day, 29th of June. They replied on the 3rd of July, telling her that as a matter of good practice, they recommended that she spend 5 days reconsidering her decision. They also said, look, this is all about capability. We'd like you to attend a capability meeting on the 10th of July. Now, on the 9th of July, her solicitors wrote in, and they said, look, she's resigned, and she's resigned because of numerous factors. The final straw was that you rejected her grievance appeal. She has decided that you have broken the duty of trust and confidence. She's entitled to resign. She won't be attending the capability meeting tomorrow. Well, 10th of July came and went. The employer responded on the 11th of July that due to Ms. Hibbert's failure to accept its offer of a capability meeting, it had no alternative but to, quotes, accept her resignation, as tendered in the letter of 29th June. And it further noted that she was required under her contract to give 4 weeks' notice, so she would remain on full pay, and that her last working day would be 27th July, and indeed they paid her up to that date. She then brought a claim of unfair constructive dismissal. Now, the case report doesn't actually say what date she lodged that claim, but there was clearly a question mark about whether it was within the 3 months. It must have been after the 29th of September, because the employer started to argue that she was too late. The effective date of termination was the date of her resignation letter of the 29th of June, and the claim was out of time. Went to the EAT, which agreed with that. The employee had expressed in that letter of the 29th of June an unambiguous decision to resign immediately without giving due notice. Even though her contract said that she should give 4 weeks' notice, she hadn't done that. It was irrelevant that her employer had actually very generously paid her as if she had. That hadn't extended her employment. So the case also illustrates that the offer of a cooling off period is just merely a way of giving the opportunity to the employee to withdraw their resignation, but she didn't do that either. Nothing she said or did subsequently amounted to a withdrawal of what had been a clear and indeed immediate resignation on the 29th of June without notice. So the 3 months started on that date and she was out of time. What do we want you to take away from it? Well, obviously look carefully if you're in receipt of a claim to see whether it's within the 3 months, but more important even than that, I said that they used the phrase, time-honoured indeed, accepted her resignation. Now, this really was misleading in this case, of course, because there is no need for an employer to accept a resignation. It's commonly used, but it's the case. There is no need for an employer to accept a resignation any more than it's necessary for an employee to accept a dismissal. They're both unilateral acts. They have effect without the need for a response from the other party. And equally, an employer can't say, I don't accept your resignation. What an employer can do is ask an employee to think again. That's effectively what happened here. Sometimes it's a good idea if a resignation has occurred, indeed a dismissal too, in the heat of the moment, then in those circumstances, yes, the law does say that it's appropriate for the party who did it to have a very short period to cool down and reverse its decision. But, as a general rule, a resignation once given can't be unilaterally withdrawn, and the same applies to a dismissal.
Okay, now we're going to look at a couple of cases that deal with remedy. Now, where a complaint of unfair dismissal has been upheld, a tribunal then has to go on and consider whether to order reinstatement or re-engagement. The tribunal is required to take into account whether the claimant wants that sort of order to be made, whether it's practicable for the former employer to comply with that sort of order, and also whether the claimant's conduct has caused or contributed to their dismissal, and whether it would be just in those circumstances to make an order of reinstatement or re-engagement. Reinstatement is putting the employee back into their old job. Re-engagement is putting them back into a different job. So the practicability of a re-engagement order is to be determined at the date that the order would take effect. So the question of practicability arose in the case of Oasis Community Learning and Wolf. Mr. Wolf was employed by OCL as a maths teacher at a secondary school. Now, following allegations about his confrontational teaching style, he was dismissed and he brought a claim for unfair dismissal. Now, in correspondence prior to the hearing, Mr. Wolf made a number of allegations against both OCL and his former colleagues, including that some of the evidence that they had given had been fabricated. At the liability hearing, OCL conceded that his dismissal was unfair. Between that and the remedy hearing, both parties then complained about the other to the regulatory bodies. Now, at the remedy hearing, Mr. Wolf accepted that it wouldn't be practicable to be reinstated at the same school, so he sought to be re-engaged at one of OCL's other schools. OCL objected, though, and they said that the seriousness of the allegations that Mr. Wolf had made about the school and also its staff made his employment impracticable. The Employment Tribunal wasn't persuaded by this, and they did order re-engagement at a different school in a different part of the country. And it pointed out that parties will often make sensitive allegations against each other in the course of a tribunal hearing, but they would be likely to behave differently and hopefully professionally once they're back at work. OCL appealed, but the EAT upheld the tribunal's decision.
Well, what about this one? In Arriva London and Eleftheriou, the claimant had several years' service as a bus driver. He then had an accident at home, rendered him unfit to drive. He had an extended period of absence, and in the end, Arriva dismissed him on the basis that they thought it was highly unlikely that he would be returning to work, certainly not in the short to medium term. As it happens, they had a policy which said that they would seek a medical report before they would dismiss somebody on health grounds. Even if they hadn't had that policy, it's obviously the right thing to do. They didn't do it. So you won't be surprised to hear that the Employment Tribunal found that the dismissal was unfair. They then went on to consider whether, if a medical report had been obtained at the time, he might still have been dismissed. And they decided that actually there was a 60% probability that he would have been on the basis of his medical condition at that time. However, the tribunal hearing was clearly some time after the event, because by then he had actually fully recovered and he was back driving. So the tribunal ordered that he should be reinstated. Arriva appealed to the EAT. Their argument was that reinstatement couldn't fairly be ordered, given that the tribunal had accepted that there was actually a 60% likelihood that they could have fairly dismissed him if they'd simply made the medical inquiries at the time. Well, the EAT said that the tribunal was right. They were entitled to reach the decision that they did. The practicality of whether you should reinstate or re-engage an employee, that is assessed at the date of the tribunal hearing, not as back at the date of the dismissal. But I wouldn't worry too much about all of this, because something like 1% of claimants, that's all, get reinstated or re-engaged, and most don't even ask for it.
And because of that, it's usually just a matter of working out the compensation. And compensation is supposed to compensate the individual for the loss caused by the dismissal, but sometimes that's not even straightforward. In R&M, Gascarth and Mooney, the AT held that an employment tribunal had been right to award a claimant loss of earnings even though she was too ill to work. Her incapacity was partly caused by depression and partly by an unrelated physical illness that wasn't caused by the loss of her job. But evidence supported the tribunal's conclusions that the claimant's depressive condition was caused by the dismissal, and that her inability to work was in no small part attributable to that condition. Her depression on its own prevented her from working, and so she was entitled to be compensated in full.
Right. Now, certain reasons for dismissal can be described as automatically unfair. In other words, the tribunal must find that there's been an unfair dismissal if that was the reason. Now, one of those is where a person has been dismissed because they made a protected disclosure. That's the legal term for whistleblowing. So in this case, Ordea Medical Services Limited and Sanderson, the EAT held that the Employment Tribunal had been right when it decided that the principal reason that Mr. Sanderson, in this case, had been dismissed was because he'd made a protected disclosure. And that was despite the fact that there was actually evidence that the employer had legitimate disciplinary concerns as well. Let's look at the facts. Mr. Sanderson was a technician employed by a company which provided medical equipment to the NHS. There was a meeting on the 15th of September 2011 where a number of disciplinary concerns were raised with him. It was alleged that he'd been rude to hospital staff, that he used to come and go as he pleased, that he was liable to breach security by using fire escape doors when leaving the building, and I think most serious of all, that he was smelly and scruffy. 12 days later, he contacted the NHS Counter-Fraud Service, alleging that he had been instructed to overcharge the NHS for repairing a particular piece of machinery. 2 days after that, he raised a grievance in which he revealed to his employers the whistleblowing phone call that he'd made. Now, the company had already had that meeting in September, and they had, in fact, drafted a letter inviting him to a disciplinary meeting, but they didn't send it at that stage. They instead decided that they would investigate the grievance first. So they did that. They rejected his grievance, and then they revived the disciplinary charges. including a new one alleging that he'd breached their whistleblowing policy by contacting an outside body without first having raised his concerns internally. He was sacked on the 25th of November. Now, he claimed automatic unfair dismissal, and as you know, because I've already told you, he won. What did the tribunal decide? Well, they first of all decided that actually, as a matter of fact, he had not actually been instructed to overcharge the NHS at all. Nonetheless, he had genuinely and reasonably believed that he had. The timing of the disciplinary process was linked to the whistleblowing, although they had had certain disciplinary concerns before they found out about his whistleblowing action. They weren't actually considered at that stage serious enough to warrant dismissal. They got jacked up a bit afterwards, and the suggestion was that he wouldn't have otherwise been sacked, so it followed that he'd been dismissed for making that whistleblowing disclosure. One further point, however, which did arise, the tribunal should have considered making a reduction to its compensation to reflect the fact that there were genuine disciplinary concerns. So even though it was an automatically unfair dismissal, what they should have done is reduced his compensation to reflect his own misconduct, because it was just inequitable to do that. Nonetheless, he won his claim.
Okay, and before we turn to redundancy, in July last year, the Employment Rights Act was amended so that the cap on the level of compensation that can be awarded in an unfair dismissal complaint for the compensatory award is now the lower of £74,200 or 52 multiplied by a week's pay of the person concerned. Now that figure is going to be updated on the 6th of April, and I would tell you what the answer is, but that might be one of your quiz questions. So if you want to put your answer and what you think that might be on the back of a £5 note and hand it to me, I'll let you know if you're right.
It's only 1 out of 10 questions, I wouldn't bother.
Okay, we're going to end this particular presentation with a look at redundancy. And there have, in fairness, been fewer cases on the subject this year, which should hopefully be a good sign. But the biggest case of them all has not yet been fully resolved. It's the one which arose out of the collapse of the Woolworths chain in 2008. And that shows you how long it takes for a case to wend its way through our domestic courts, and it's now winging its way to Europe. But we'll give you a little refresher first. So this case is all about collective redundancies. So if you're proposing to make 20 or more employees redundant at one establishment within a 90-day period, you have to engage in collective consultation with workplace representatives. So if you have a recognised trade union, you'll consult with that union. If you don't, then you'll need to ask the workforce to elect some representatives by secret ballot. And then once that's in place, the length of consultation required depends on the numbers involved. So if you're looking to dismiss between 20 and 99 people inclusive, the consultation period is 30 days. If it's 100 or more, the period is now 45 days, reduced from 90. But the penalty for failing to do that is still the same. It's up to 90 days pay for each affected employee. So that highlights why it's so important to get this right.
Now, the point which arose actually in the Woolworths cases was this. The requirement to consult is defined in the UK legislation as arising where the number of proposed redundancies at one establishment is 20 or more. There's always been a question mark over the meaning of establishment. Obviously, a company may have a number of separate premises. They may manage them centrally. Are they separate establishments for this purpose? Now, in the case of Woolworths, they had hundreds of stores, obviously, across the country, some employing fewer than 20 people, some not. They had no collective consultation at all, so the union brought claims for protective awards, as they're called, of 90 days pay on behalf of 27,000 employees, rather clogged up the tribunals. It was conceded that those who worked in stores where 20 or more people were employed were entitled to this compensation, but not those who worked in the smaller stores. It was argued that each store was a separate establishment. Well, when this went to the EAT, they had a look at the European directive with which we have to comply, and they couldn't find any reference to establishments in there. So they've referred it, in fact, the Court of Appeal has now referred it to the European Court of Justice. So we're in a bit of limbo, but at the moment, what you need to be aware of is that the last view on the matter said that if your business operates over more than one site, the law at present requires you to count all of them in if you're having to work out whether you need to consult with workplace representatives.
Employees who are dismissed as redundant frequently complain about the employer's criteria for selecting them for redundancy and say that they were unreasonable, and that in turn made their dismissal unfair. And generally speaking, the more objective the criteria, the more likely the selection will be seen to be fair. But as the next case shows, using an objective process doesn't provide you with an automatically cast iron defence against possible claims. In mental health care in Billion, the company was consulting with 19 employees over the possible closure of a ward at the company's hospital in Anglesey. Selection for redundancy was to be made from a pool of all nursing and support staff at the hospital on the basis of 3 criteria: competency, which was going to account for 60% of the points, disciplinary record, and also absence record. And the company decided to assess employees' competency in accordance with a process it normally used for recruitment, which consisted of a written assessment, an interview, and a verbal group assessment. So there was no use that was going to be made of employees' past performance appraisals. The written assessments were marked by members of the assessment team, which comprised 5 HR professionals and a recruitment manager, followed by a moderation process to ensure a uniform approach. Then interviews were carried out by an HR professional together with a nursing or support staff manager, and then 2 HR managers conducted the verbal group assessments. But none of the assessment team had any experience of working with the individuals who were being assessed themselves. The employees with the lowest scores were made redundant, including the claimant, and they complained of unfair dismissal. Well, you might say, well, this all sounds extremely thorough and very objective, but the Employment Tribunal decided that the competency criteria were grossly unfair. And actually, I think if you look at it, you can see why. It said that the company should have considered matters such as the employee's length of service and their appraisal records, and importantly, the views of the managers who actually knew them. They also added that, for good measure, the criteria had been applied unfairly because, amongst other things, the verbal group assessments favoured employees with an outgoing personality. Now, I think probably the tribunal was going a little bit far there, but interestingly, in this case, the AT has, again, upheld the tribunal's decision. What the AT said was that it was very unusual for an employer going through a redundancy selection exercise based primarily on competency to then base its decision entirely on assessments which fail to take into account past appraisals or the views of managers with whom they had worked closely with the employees and obviously knew about their standards of work. The criteria were applied objectively, but if anything, too objectively. They removed the subjective elements completely. And the company had used what the EAT described as an elaborate and HR-driven method which deprived it of the benefit of input from managers and others who actually knew the staff in question, and which by its very elaborateness was liable to be difficult to apply consistently.
Last case on redundancy is this one. As I'm sure you all know, before you actually make a person redundant, you do need to look to see whether you can offer them what we call suitable alternative employment. And a person who actually unreasonably refuses an offer of suitable alternative employment risks forfeiting their right to a redundancy payment. So in Devon Primary Care Trust and Redman, that was the issue. Mrs. Redman was a community-based matron. She'd actually worked for the NHS for a long, long time, and since 1985, she'd actually been a community nurse, following that, a community modern matron. She hadn't been based in a hospital. There was then a restructuring, and Mrs. Redman was told, you are at risk, and she was offered alternative positions, including a position as a modern matron, but based in a small community hospital. She actually rejected that job because she said, I don't want to go back into a hospital after all these years, even though it was actually very clear that the job was very similar to what she was doing as a community matron. She knew the hospital layout, she knew many of the staff, it was found that she only needed to familiarise herself with the procedures. Her skill set was completely transferable. She also happened then to take a job in Canada as a community nurse, and the tribunal had not a great deal of sympathy. They thought that she actually had been looking to emigrate but pocket her redundancy at the same time. So they found against her. They decided she had forfeited her right to redundancy by refusing the job as a hospital matron. Went to the EAT. The EAT said, no, that's wrong, or at least it's potentially wrong. They've sent it back to the tribunal, and what they said was this: objectively, that was suitable alternative employment. Can't fault the job objectively. But there is a second test, which the tribunal hadn't really focused on, which is whether the individual, looked at subjectively, was actually reasonable in saying no. And what they said was, well, her case was she really couldn't face going back into a hospital environment. You needed to explore that. You needed to find out whether she was actually reasonable in saying that was her reason for refusing. They hadn't done that. So the case has been sent back to the tribunal to consider further, which means, of course, that Mrs. Redman will have to come all the way back from Canada if more evidence is now needed. So I hope, well, for her sake anyway, I hope it proves worth it.